Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It discusses historical trends, legal evolutions, and sociological data regarding divorce and parental rights across various nations. This information does not constitute legal, financial, or psychological advice. Laws regarding custody, child support, and divorce vary significantly by jurisdiction and are subject to frequent change. Viewers should conduct their own due diligence and consult with qualified professionals, such as attorneys or family therapists, regarding their specific personal circumstances. In the United States, we are often told that divorce is a 50-50 proposition, a clean break where both parties eventually find their footing. But for the American father, history tells a much darker and more complex story. Imagine a world where, by simply signing a piece of paper, a man loses 70% of his access to his children, 40% of his post-tax income, and his primary social support network overnight. While the U.S. has seen a 42.5% reduction in divorce rates over the last 20 years, the historical baggage of the American legal system remains a gauntlet that few men are prepared to run. Contrast this with Sweden, where joint physical custody is the default for nearly 40% of all separated families, or Italy, where divorce rates remain among the lowest in the industrialized world at just 12%. Why is the American experience of fatherhood after divorce so uniquely volatile? Why does the U.S. system seem to prioritize the empire of the judge over the empire of the father? Today, we are opening a deep dive investigation into the historical evolution of the divorced dad, comparing the American trajectory against global counterparts to uncover why the U.S. father is facing a crisis that other nations solved decades ago. This deep dive solves a critical problem for the modern American man: the lack of historical and global context. Most men enter the family court system believing they are fighting a personal battle, unaware that they are actually caught in the gears of a 150-year-old legal machine designed for a society that no longer exists. By understanding how we got here, and how countries like Denmark or Japan handle the same issues, you will gain the clarity needed to navigate the current landscape of parental rights, financial obligations, and social reintegration. To understand the plight of the modern American father, we have to travel back to the 19th century, a period that laid the foundation for every deadbeat stereotype and every lopsided custody hearing we see today. Historically, in both English common law and early American law, fathers actually held absolute rights. This was known as the paternal preference. Under this doctrine, children were seen almost as property of the father's estate. If a marriage ended, the children stayed with the father because he held the economic resources to provide for them. However, a seismic shift occurred in the mid-1800s with the introduction of the tender years doctrine. This legal principle argued that during their youngest, most tender years, children required the unique emotional care of their mother. What began as a compassionate exception for infants soon became the rigid rule for all children. By the early 20th century, the U.S. had effectively flipped from 100% paternal preference to nearly 100% maternal preference. This transition was not just a legal shift, it was an economic one. As the Industrial Revolution moved men out of the home and into factories, the breadwinner model was codified into law. If a man was only valuable for his paycheck, then in the eyes of the court, his presence in the home was secondary to his ability to fund it from the outside. While the U.S. was doubling down on the tender years doctrine, other nations were taking a different path. In many Mediterranean and Eastern European cultures, the nuclear family was never the sole unit of measure. In Italy, for instance, the influence of the Catholic Church and the extended family meant that divorce was not just legally difficult, it was socially catastrophic. Because the extended family, grandparents, aunts, uncles, played such a massive role in child-rearing, the removal of a father through divorce was seen as an affront to the entire kinship network. Consequently, even when divorces occurred, the social pressure to maintain the father's role was enforced by the community, not just the court. In the United States, the 1970s brought the no-fault revolution, spearheaded by California in 1969. Before this, you had to prove fault, adultery, cruelty, or abandonment to get a divorce. No-fault divorce was intended to reduce conflict, but for fathers, it created a historical paradox. It made exiting a marriage easier, but it did nothing to update the custody laws that were still stuck in the 1920s. The result was a massive spike in disposable fatherhood. Case studies from the 1980s show that as divorce rates climbed to their historic peak, the percentage of fathers who saw their children, less than once a month skyrocketed to nearly 50% within 2 years of the split. The financial machinery followed suit. In 1935, the Social Security Act created Aid to Dependent Children, ADC, originally designed for widows. By the 1960s and 70s, the program was being used primarily for divorced or never married mothers. To recoup these costs, the U.S. government shifted from a welfare mindset to an enforcement mindset. This led to the 1975 creation of the Child Support Enforcement, 4D program. Suddenly, the American father was no longer just a parent. He was a debtor in a federal system. This is a uniquely American development. In many Northern European countries, child support is seen as a social safety net where the state guarantees a minimum payment to the child, and then works with the father based on his actual ability to pay, rather than using the threat of incarceration as a primary collection tool. Furthermore, we must examine the specialization gap. Historically, the American male breadwinner model created a situation where men specialized in income and women specialized in domestic labor. When divorce happens in this model, the specialization penalty hits both sides, but it hits fathers in a way that is often ignored by data. While women often see a steeper drop in household income, a trend that is fortunately converging as more women enter high-paying careers, men experience a much higher rate of downward mobility in terms of health and social status. Longitudinal studies indicate that divorced men in the U.S. have a significantly higher risk of becoming disabled, unemployed, or suffering from clinical depression compared to their married counterparts. This is often linked to the social capital lost during a divorce. In the U.S., a man's social life is often managed by his wife. When that connection is severed, he finds himself in a vacuum. Compare this to the Nordic model. In countries like Denmark and Sweden, where gender roles are more fluid and both parents are expected to work and care for children equally, the divorce penalty for fathers is significantly lower. Because these fathers were already specialized in childcare before the divorce, the transition to joint physical custody is seamless. They don't have to prove they are capable parents to a judge. The society already assumes they are. As we move through this 10-part masterclass, we will look at the step-by-step mechanics of how these historical trends created the modern American family court. We will look at the best interests of the child standard, a term that sounds noble but, as we will see, has historically been used to grant judges nearly unlimited discretion to separate fathers from their homes. We will compare the adversarial winner-take-all system of the U.S. with the mediation-heavy systems of Japan and Germany. The problem for you, the viewer, is that you are living in a country that is currently in a state of legal lag. Our culture has moved toward wanting involved hands-on fathers, but our legal and financial institutions are still operating on a 1975 OS. By looking at the potential outcomes of different international models, we can begin to see a roadmap for reform. This isn't just about history. It's about the future of your family and your rights. Stay tuned because in the next part we are going to break down the primary caregiver myth and how it is used as a weapon in modern litigation. The primary caregiver standard is the modern evolution of the tender years doctrine, and it is perhaps the most misunderstood weapon in the arsenal of family law. On the surface, it sounds entirely logical. The court asks a seemingly simple question: who has been doing the day-to-day work of raising the child? Who is the person who knows the name of the pediatrician, who packs the lunches, and who manages the bedtime routine? In a vacuum, this seems like a fair way to determine stability. However, when we apply this to the historical context of the American workforce in 2026, we see a massive structural bias that often leaves fathers on the outside looking in. Imagine a man named David, a project manager in Chicago. For the last 10 years, David has worked 50 hours a week to provide for his 2 children. He is the one who took the promotion that required a longer commute so his family could move into a safer school district. He is the one who stayed late at the office to ensure the mortgage was paid and the college fund was growing. Because of this economic specialization, his wife was able to work part-time or stay home, handling the majority of the school runs and doctor appointments. In the eyes of the law, David has been a provider. But the moment a divorce petition is filed, that same law often reclassifies David's provider status as evidence of his absence. The primary caregiver standard effectively penalizes the parent who specialized in income generation. In many U.S. jurisdictions, the court looks at the status quo of the last 6 to 12 months. If one parent was home more, they are designated the primary caregiver, and the other parent is relegated to a visitor role. This creates a historical trend where the very sacrifices a father made to support his family are used as the legal justification to limit his time with them once the marriage dissolves. Now, contrast David's situation in the US with a case study from Iceland. In Iceland, the legal framework operates on a completely different set of historical assumptions. Since 2003, Iceland has utilized a use it or lose it paternity leave system. Both parents are given equal, non-transferable periods of leave after a child is born. This historical policy change was designed to ensure that from day one, both parents are equally competent in the primary care of the child. When a divorce occurs in Reykjavik, the court does not ask who the primary caregiver was because the structural assumption is that both parents are primary caregivers. There is no historical bias toward one parent based on economic specialization, because the state has incentivized both parents to be present in the home from the start. In the United States, we see a recurring pattern where the primary caregiver standard is used as a tactical maneuver during the initial separation. Because the legal process can take 18 months or longer to reach a final decree, the temporary orders issued at the start of the case often become the permanent reality. This is known as the status quo bias. If a father is granted every other weekend in a temporary hearing, and he follows that schedule for a year while waiting for trial, the court often rules that the children have become accustomed to this arrangement and that changing it would be disruptive. Thus, the temporary disadvantage becomes a permanent legal ceiling. We also have to look at the historical data regarding the secondary parent trap. In the US, once a father is labeled the secondary parent, his influence on major life decisions, education, healthcare, and religious upbringing often diminishes to a consultative role rather than a collaborative one. This is vastly different from the French model. In France, the concept of autorite parentale is a fundamental right that is rarely severed. Even if one parent has the children for more nights of the week, both parents retain an equal and absolute legal standing in all major decisions. The French system prioritizes the continuity of the paternal bond as a matter of public policy, viewing it as a right of the child rather than a privilege granted to the father by a judge. The depth of this issue in the US is compounded by the adversarial nature of our litigation. Because the primary caregiver standard is a winner-take-all metric, it incentivizes parents to document and highlight the failures of the other. It turns the domestic history of a family into a balance sheet of chores and minutes spent. If a father cannot prove he attended 100% of the parent-teacher conferences because he was at work providing the tuition for the school, that data point is logged against him. Let's look at another case study, this time from Brazil. In 2014, Brazil passed a landmark law making joint custody the default rule. Before this, Brazil faced similar issues to the US, where fathers were often marginalized after a split. The Brazilian legislature realized that the best interests of the child were actually served by a mandatory presumption of shared time. This shifted the burden of proof. In the US, a father often has to prove why he should have 50% of the time. In the new Brazilian model, a parent has to prove why the other parent should not have 50% of the time. This subtle shift in the burden of proof fundamentally changes the power dynamics of the negotiation. In the American system of 2026, we are also seeing the rise of virtual presence as a point of contention. With the advent of high-definition video calling and remote monitoring, the definition of presence is changing. Yet, many family courts still rely on the physical presence metrics established in the 1970s. A father who is on a business trip but reads a bedtime story to his children every night via a tablet is often still viewed by the court as away. The legal system has not yet caught up to the reality of the digital-age father, who remains an active participant in his children's lives through technology, regardless of his physical location. The financial implications of the primary caregiver standard are equally profound. In many states, child support calculations are tied directly to the number of overnights. This creates a perverse financial incentive for the primary parent to limit the time the secondary parent spends with the children. If the father moves from 30% time to 50% time, the child support payment might drop by hundreds or even thousands of dollars. This turns the children into a financial asset, where time is literally money. In countries like Germany, child support is calculated using the Dusseldorf table, a more standardized and transparent system that aims to decouple the emotional and physical needs of the child from the purely tactical movements of the parents. By examining these historical trends in international case studies, we see that the American divorced dad is not a victim of a single bad judge or a single bad law. He is the product of a specific historical trajectory that prioritizes economic provision during marriage and penalizes it during divorce. We have built a system that expects men to be providers in the office and primary caregivers in the courtroom, two roles that are often structurally incompatible under current U.S. labor and legal norms. But what happens when the legal battle moves beyond just who gets the kids on Tuesdays? What happens when the state decides your very identity as a father is a debt to be collected? In the next part of this deep dive, we are going to look at the dark history of the deadbeat dad narrative. We will uncover how a specific 1980s media campaign changed the way society views struggling fathers, and how other nations have managed to keep fathers engaged without the threat of a jail cell. We will look at why the U.S. spends more on child support enforcement than almost any other nation on Earth, yet continues to see a growing gap in paternal involvement. The numbers will shock you, and the history behind them is even more disturbing. Stay tuned for Part 3. The concept of the deadbeat dad is so deeply ingrained in American culture that it feels like a timeless truth, but historically, it is a relatively modern invention. To understand how we got to the current state of 2026, we have to look back at the 1980s. This was the decade when the United States government shifted its focus from supporting families to aggressive collection. In 1984, the Child Support Enforcement Amendments were signed into law, followed by the Family Support Act of 1988. These laws mandated that states implement numeric guidelines for child support and wage withholding. But the real shift wasn't just in the law, it was in the marketing. Imagine a man named Robert in 1985. Robert worked in a manufacturing plant in Ohio that closed down. He lost his job, his marriage collapsed under the financial strain, and he fell behind on his newly court-ordered payments. Under the previous era of law, Robert might have been seen as a man in a temporary crisis. But in the mid-80s, a massive media campaign began to categorize men like Robert not as victims of economic shifts, but as moral failures. The term deadbeat dad began appearing in headlines across the country, used to describe any father who was non-compliant with a payment schedule, regardless of the reason. This historical trend created a feedback loop. By labeling struggling fathers as criminals, the system justified increasingly punitive measures. In the U.S., if you fall behind on child support, the state can revoke your driver's license, your professional licenses, and your passport. In many states, you can be incarcerated for civil contempt. Think about the logic of that for a moment. The state takes away a man's ability to drive to work or perform his job as a way to force him to pay money he doesn't have. This is a uniquely American approach that views the father-child relationship primarily through a fiscal lens. Now let's look at a case study from the Netherlands. The Dutch approach to non-payment is fundamentally different. In the Netherlands, if a father cannot pay, the government conducts a capacity to pay investigation. They don't just look at what he earned 3 years ago, they look at his current bank balance, his rent, and his ability to find work. If the father is genuinely destitute, the state provides a socialized advance to the child, ensuring the child is fed without criminalizing the father. The goal in the Netherlands is to keep the father in the child's life, recognizing that a father who is in prison or has no license is of zero value to his child's development. The U.S. system, by contrast, often treats the debt as an immutable figure that survives even bankruptcy. In the United States, the federal government actually provides financial incentives to states to collect child support. Under Title 4D of the Social Security Act, the federal government pays states a percentage of the money they collect. This has created a massive enforcement industry. In 2026, the U.S. spends billions of dollars annually on the administrative costs of tracking down fathers and enforcing orders. This creates a historical paradox. We spend more money trying to extract payments from low-income fathers than the value of the payments themselves. The impact of this enforcement-first model is particularly visible when we look at the historical data on paternal drift. When a father is under the constant threat of incarceration or loses his license, he often goes underground. He moves to the cash economy, he avoids formal employment, and because he feels like a criminal in the eyes of the state, he begins to withdraw emotionally from his children. Case studies in urban sociology have shown that the fear of the legal system is one of the primary drivers of father absence in low-income American communities. The system designed to make him pay often ends up making him disappear. Contrast this with the Japanese model. In Japan, the culture historically emphasizes a clean break after divorce. While this has its own significant flaws, which we will discuss later, the Japanese government has recently begun moving toward a model of visitation mediation. Instead of focusing solely on the money, the Japanese Ministry of Justice is experimenting with programs that prioritize the emotional connection. They recognize that when a father feels like a valued part of his child's life, he is statistically more likely to contribute financially without the need for a badge or a set of handcuffs. Imagine the psychological toll on a father in 2026 who is told by a judge that his value is exactly $842 per month. If he pays it, he is a good father regardless of whether he sees his kids. If he doesn't, he is a deadbeat, regardless of whether he spent every weekend coaching their soccer team. This commodification of fatherhood is a historical byproduct of the U.S. welfare reforms of the late 20th century. The state needed to reduce its welfare rolls, and the easiest way to do that was to designate the father as the primary source of funding, even if that father was also living below the poverty line. There is also the historical issue of imputed income. In the U.S., if a father loses a high-paying job, the court can decide that he should be making that same amount of money, regardless of the job market. They impute his income, meaning they set his support based on what he could potentially earn. If a software engineer is laid off in a 2026 tech crunch and has to take a job at a warehouse, the court may still order him to pay support as if he were making six figures. If he can't, the arrears start to pile up at interest rates that are often higher than a credit card. In many states, these arrears are non-modifiable. Even if he eventually gets a better job, he may spend the rest of his life paying off the interest on a debt that was mathematically impossible to pay at the time. In Australia, the system is much more flexible. The Australian Child Support Agency uses a formula that accounts for both parents' incomes and the actual percentage of care each parent provides. Most importantly, it is updated annually based on tax returns. It is an administrative process rather than a judicial one. This removes the adversarial theater of the courtroom. Australian fathers are less likely to be labeled as deadbeats because the system adjusts to their actual economic reality in real time, rather than relying on a static and often outdated court order from 5 years prior. As we look at these historical trends, we begin to see that the American divorced dad is caught in a pincer movement. On one side, he is fighting a custody system that still views him through the lens of the 19th century tender years doctrine. On the other side, he is fighting a collection system that views him through the lens of a 1980s criminal justice campaign. The result is a uniquely American form of fatherhood that is high stress, high debt, and low access. But the financial and legal aspects are only half the story. There is a much more subtle and perhaps more damaging historical trend at play: the gatekeeping phenomenon. How did it become culturally acceptable for one parent to control the other's access to the children? And why do some nations treat this as a psychological emergency while the U.S. often looks the other way? In the next part, we are going to dive into the history of maternal gatekeeping and parental alienation. We will look at the controversial case studies that have shaped modern psychology, and how countries like Brazil have actually made alienation a crime. We will examine the specific tactics used to fade a father out of his child's life, and the long-term historical impact on the children who grow up in the middle of this Cold War. You won't want to miss the data on how this affects the next generation. Stay tuned for part 4. To understand the Cold War of the modern divorce, we have to look at a concept that sociologists call gatekeeping. Historically, in the United States, the domestic sphere was the one area where women held undisputed authority. As divorce rates climbed in the 1970s and 1980s, this domestic authority often transformed into a form of border control. Maternal gatekeeping is a collection of behaviors that either facilitate or inhibit a father's involvement with his children. While many mothers act as facilitators, the American legal structure has historically provided a massive incentive for the inhibitors. Imagine a man named Mark in 2026. Mark is a devoted father, but since the separation, he has found that every request to see his daughter is met with a logistical hurdle. Suddenly, the child is sick every Friday at 5 p.m. The soccer schedule is changed without his knowledge. When he does get his schedule time, he is bombarded with text messages questioning his choice of food, his choice of movies, and his ability to supervise homework. This is the subtle version of gatekeeping. The overt version is what researchers call parental alienation. This is the psychological process where one parent systematically programs a child to distance themselves from, or even hate the other parent. In the United States, the history of parental alienation as a legal concept is fraught with controversy. For decades, it was dismissed by many courts as a junk science or a legal tactic used by abusive fathers to regain control. However, by 2026, the psychological community has increasingly recognized the devastating historical trends associated with this behavior. Longitudinal data now shows that children who are successfully alienated from a father suffer from higher rates of substance abuse, educational underperformance, and a lifetime of attachment disorders. Yet, the U.S. court system is notoriously slow to react. In many states, a father must endure years of litigation and spend tens of thousands of dollars on forensic evaluators just to prove that his lack of a relationship with his child is not his fault. Contrast this American struggle with the legal landscape in Brazil. In 2010, Brazil took a radical step that sent shockwaves through the global legal community. They passed the Parental Alienation Act. Under this law, interfering with a child's relationship with their other parent is not just a civil matter. It is a violation of the child's fundamental rights. Brazilian judges have the authority to issue fines, change custody arrangements immediately, and even order psychological treatment for the alienating parent. The historical outcome of this law has been a shift in the national consciousness. Because there is a clear, enforceable penalty, parents are forced to prioritize the child's need for both parents over their own personal grievances. The United States, meanwhile, relies on a reactive system. If a father in Georgia or California is being denied his court-ordered time, his primary recourse is to file a motion for contempt. This process can take months. By the time the hearing arrives, the alienating parent may simply pay a small fine or receive a verbal warning, and the cycle begins again. This creates a historical trend of father erosion. If a father is denied access for 6 months, the emotional bond begins to fray. The child, feeling the tension, may eventually say they don't want to go to the father's house just to stop the conflict. The court then looks at this child's preference and codifies the alienation into a permanent order. We must also examine the case study of Mexico. Historically, Mexico was a bastion of traditional gender roles, where the mother was the undisputed heart of the home. However, in recent years, the Mexican Supreme Court has issued several landmark rulings emphasizing that the right to a biparental upbringing is a human right. They have moved toward a model where the state actively intervenes to prevent one parent from becoming a gatekeeper. This highlights a fascinating historical shift. Traditionally conservative or patriarchal societies are often moving faster toward shared parenting than the supposedly progressive U.S. system, largely because they view the family as a permanent social unit that exists beyond the death of a marriage. Now, let's look at the historical data on the next generation. What happens to the children of these gate-kept fathers? In 2026, we have access to 40 years of data following the children of the Great Divorce boom of the 1980s. The results are clear. Children who maintained a high-quality relationship with their fathers, even in high-conflict divorces, showed significantly better potential outcomes in emotional regulation and career stability. In contrast, those who were caught in the crossfire of gatekeeping and alienation often struggle with a phenomenon called split loyalty. These children feel that loving one parent is a betrayal of the other. Historically, this leads to a cutoff in early adulthood, where the child eventually realizes the manipulation and severs ties with the alienating parent, leading to a second wave of family trauma. Imagine if the U.S. adopted the Israeli model. In Israel, the state utilizes domestic relations offices to act as a buffer between the parents. If a father is denied his time on a Friday, he doesn't call a lawyer. He calls a social worker who has the power to intervene that same day. The Israeli system recognizes that time is the most valuable currency in a parent-child relationship. Once a weekend is lost, it is gone forever. The historical trend in Israel has been to treat custody interference as an emergency, similar to a medical crisis, rather than a slow-moving contract dispute. The depth of this issue in America is exacerbated by the conflict industry. Because the U.S. legal system is adversarial, lawyers often profit from the escalation of gatekeeping. Every missed visit is a new motion. Every angry text is a new exhibit. In many European nations, such as the Netherlands or Norway, parents are often required to go through mandatory mediation and parenting coordination before they are even allowed to step into a courtroom. This historical focus on de-escalation prevents the gatekeeping behaviors from becoming entrenched habits. In the U.S., we are also seeing a historical rise in relocation litigation. This is the ultimate form of gatekeeping. In an increasingly mobile society, one parent may decide to move 1,000 miles away for a job or a new relationship. Historically, U.S. courts have been split on this, but many still allow the primary parent to move, effectively ending the father's day-to-day involvement. In the United Kingdom, the historical trend has shifted toward a proximity requirement. The courts there are increasingly skeptical of moves that would destroy the child's relationship with the non-moving parent, recognizing that a better job for a parent rarely outweighs the loss of a father for the child. As we peel back the layers of these historical and international comparisons, a clear picture emerges. The American father is fighting an uphill battle against a system that often rewards the gatekeeper and punishes the provider. But how do these dynamics change when we add the most volatile element of all? The transition of the household itself. In the next part, we are going to look at the history of the step-parent trap. We will explore how different cultures integrate new partners and the specific legal hurdles American dads face when their children's home becomes a revolving door of new influences. We will examine the data on social fathers versus biological fathers and why the U.S. is uniquely obsessed with replacing the original father figure. This is where the emotional stakes reach a breaking point. Stay tuned for Part 5. The step-parent trap is a sociological phenomenon that has accelerated in the United States over the last 4 decades, creating a historical trend where the biological father is often treated as a legacy component rather than a core necessity. In the American legal and social consciousness of 2026, we see a recurring pattern. The arrival of a new partner in the mother's home frequently signals the beginning of the end for the biological father's influence. This is not just a personal struggle. It is a structural reality built into the way the U.S. handles blended families. Imagine a man named Christopher. He has been divorced for 3 years and maintains a consistent, though limited, schedule with his 2 young sons. He pays his support, he shows up for soccer games, and he is the secondary parent in the eyes of the law. Then his ex-wife remarries. Her new husband, the stepfather, is now in the home 7 days a week. He is the one helping with the 7 a.m. breakfast and the 8 p.m. bedtime. Slowly, the terminology begins to shift. The kids start calling the stepfather some variation of dad. The school starts calling the stepfather for emergencies because he is the one 10 minutes away. In the United States, there is very little legal protection for Christopher's status during this transition. In fact, the U.S. system often encourages the integration of the social father at the expense of the biological father to create what the courts call a stable nuclear unit. This historical drive toward the replacement of the father figure is unique when compared to other global models. Take, for example, the case study of Italy. In Italian culture and law, the concept of the biological family is almost sacred. Even when a mother remarries, the stepfather's role is clearly delineated as a supportive one, not a replacement one. There is an enormous amount of social pressure for the step-parent to respect the territory of the original father. Historically, Italian law makes it incredibly difficult for a step-parent to gain any form of legal authority over a child if the biological father is still in the picture. The state views the bond between the biological father and child as an immutable legal fact that no amount of new domestic arrangements can overwrite. In the United States, however, we have the historical precedent of psychological parenthood. This legal theory suggests that whoever is providing the daily emotional and physical care is the true parent in the eyes of the child. While this was designed to protect children in foster care or non-traditional settings, it is frequently used as a tool in high-conflict divorces to marginalize biological fathers. If a stepfather has been in the home for 2 years, a lawyer might argue that he has become the psychological parent, and therefore, the biological father's visitation should be curtailed to avoid confusing the child. This creates a historical trend of replacement therapy, where the original father is phased out of the family's daily narrative. Now, contrast the U.S. experience with the French model of the extended family council. In France, when a major change occurs, like a parent remarrying or moving, the court can convene what is essentially a family meeting. This isn't just a hearing between 2 lawyers. It can involve extended family members. The goal is to ensure that the arrival of a new adult does not disrupt the child's existing bonds. French law operates under the historical assumption that a child cannot have too many people who love them, but they can only have one father. This prevents the winner-take-all competition we see in American households where the biological dad and the stepdad are often pitted against each other in a battle for the child's loyalty. We must also look at the financial dimension of the step-parent trap. In the U.S., a mother's remarriage to a wealthy man rarely results in a decrease in the biological father's child support obligations. Historically, the law treats the mother's new household income as irrelevant to the father's debt. This can lead to a situation where a biological father is struggling to survive, paying a significant portion of his income to a household that is now significantly wealthier than his own. This creates a historical bitterness that further erodes the father's desire to stay engaged. Case studies from the 2010s and 2020s show that this perceived financial injustice is a primary reason why many American fathers eventually drift away. They feel like they are paying for the privilege of being replaced. In Thailand and other parts of Southeast Asia, the historical trend is vastly different. There is a concept of the communal father. When a marriage ends and new partners enter, the biological father's role is often bolstered by his own extended family. His parents, the paternal grandparents, remain central figures in the child's life. In the U.S., paternal grandparents are often the forgotten victims of divorce. If the mother decides to limit the father's time, the grandparents usually lose their access as well. Historically, U.S. courts have been very reluctant to grant grandparent visitation rights, following the 2000 Supreme Court case Troxel v. Granville, which prioritized the custodial parent's right to choose who sees the child. This means that in America, when you lose the father, you often lose an entire side of the child's heritage. Imagine if the U.S. adopted the Brazilian approach to the multi-parental family. In 2011, the Brazilian Supreme Court recognized the concept of socio-affective parentage alongside biological parentage. This might sound like the U.S. version of replacement, but there is a crucial difference. It is additive, not subtractive. A child can have both a biological father and a socio-affective father listed on their birth certificate, both with legal rights and responsibilities. This removes the zero-sum game. The stepfather can be involved without the biological father having to be erased. This historical shift acknowledges the reality of modern life without destroying the foundational bond of biology. The data for 2026 shows that the most successful potential outcomes for children in blended families occur when the biological father's role is explicitly protected and respected by the new partner. However, the U.S. adversarial system is not built for cooperation. It is built for conflict. When a new stepfather enters the scene, he is often encouraged by the mother's legal team to take an active role in protecting the new family unit from the intrusive biological father. This turns the domestic space into a fortress. As we examine this historical comparison, we see that the U.S. is one of the few nations that treats fatherhood as a fragile status that can be easily overridden by a new marriage or a new domestic arrangement. We have created a culture of the disposable dad, where a man is expected to provide financially for a home he is no longer allowed to enter, and for children who are being taught to look elsewhere for leadership and love. But what happens when this pressure reaches the boiling point? What are the physical and mental health consequences for the men caught in this machine? Why is the suicide rate for divorced fathers in the U.S. so much higher than in countries with shared parenting defaults? In the next part, we are going to look at the health crisis of the American divorcee. We will examine the shocking historical data on life expectancy, heart disease, and mental health among divorced men in the U.S. versus the U.K. and Japan. We will dive into the science of social isolation and why the American model of divorce is literally killing fathers. You will see why this is a public health emergency that no one is talking about. Stay tuned for Part 6. The health crisis of the American divorced father is a silent epidemic that has been brewing since the 1970s, and by 2026, the data has become impossible to ignore. In the United States, the historical trend suggests that marriage acts as a primary health insurance policy for men. It provides social regulation, nutritional stability, and emotional monitoring. When that structure is dismantled through an adversarial legal process, the biological fallout for the father is often catastrophic. We aren't just talking about sadness. We are talking about a measurable decline in physiological resilience. Imagine a man named Michael in 2026. Before his divorce, Michael was a healthy 40-year-old with slightly elevated blood pressure, but a stable lifestyle. Post-divorce, Michael finds himself in a studio apartment, socially isolated from the couples he used to spend time with, and under intense financial pressure to meet his child support obligations. Historically, men like Michael experience a 250% increase in the risk of mortality compared to married men. In the U.S., divorced men are statistically more likely to suffer from cardiovascular disease, strokes, and a weakened immune system. This is often attributed to the loss of what sociologists call the health guardian role typically played by a spouse. Without someone to encourage a doctor's visit or notice the early signs of exhaustion, the American father often works himself into a physical breakdown. When we look at historical trends in suicide rates, the numbers are even more chilling. In the United States, divorced men are 8 times more likely to take their own lives than divorced women. This disparity is one of the largest in the public health sector. The correlation between the loss of parental contact and the onset of suicidal ideation is incredibly high. For many American fathers, their identity is inextricably linked to their role as a provider and a protector. When the court removes the protector role by limiting custody and heightens the provider role to an unattainable level through aggressive support orders, the resulting identity crisis can be fatal. Now let's look at a case study from the United Kingdom. While the UK has faced its own challenges with family law, their public health approach to divorced fathers has begun to diverge from the US model. In the UK, organizations like Man Down and various NHS initiatives have historically recognized that male social isolation is a clinical emergency. They have implemented social prescribing, where doctors can refer divorced men to peer support groups specifically designed to rebuild their social capital. Unlike the US, where the burden of recovery is placed entirely on the individual, the UK historical trend has moved toward acknowledging that the state has a vested interest in keeping these men healthy and productive. In Japan, we see a different but equally intense historical health trend known as kokoro no yamai, or sickness of the heart. For Japanese fathers who lose contact with their children, often completely due to the country's lack of joint custody laws, the health outcome is frequently manifested in karoshi, or overwork to the point of death. Without the emotional anchor of the family, many Japanese fathers pour themselves entirely into their corporate roles as a form of escapism, leading to a unique intersection of social isolation and physical collapse. However, the Japanese government is currently facing a demographic crisis and is beginning to realize that the health of fathers is essential for the stability of the workforce, leading to slow but steady shifts in parental leave and support systems. We must also examine the science of cortisol and chronic stress. In the U.S. adversarial system, the litigation process can last for years. This keeps the father in a state of chronic fight or flight. Historically, prolonged exposure to high cortisol levels leads to neurobiological changes. It affects the hippocampus, which handles memory, and the prefrontal cortex, which handles decision-making. In a 2026 context, we see that fathers in the middle of a 2-year custody battle are literally losing the cognitive ability to perform their jobs effectively. This creates a secondary health crisis, the loss of career and the subsequent loss of the health insurance that was tied to that career. Compare this to the potential outcomes in Denmark. In the Danish system, the historical focus is on minimizing the duration of the conflict. Most custody disputes are resolved through administrative mediation within 90 days. By drastically shortening the window of uncertainty, the Danish state limits the physiological damage to the father. Data from the Nordic countries shows that fathers who undergo rapid, mediated separations have significantly lower levels of stress-related illnesses than American fathers who are locked in the multi-year litigation cycle. Imagine the impact of the U.S. litigation tax on a man's health. Every dollar spent on an attorney is a dollar not spent on high-quality food, a gym membership, or therapy. In 2026, the average high-conflict divorce in a major U.S. city can cost a father upwards of $50,000. Historically, this financial depletion forces men into substandard housing and poor nutritional habits. We see a recurring case study of the divorced dad diet: high sodium, processed foods eaten in isolation. This isn't a joke. It's a precursor to the metabolic syndrome that claims the lives of thousands of American men every year. There is also the historical reality of the loneliness gap. In American society, men often rely on their wives to maintain the couple's social calendar. Post-divorce, a man often finds that the friends he thought were theirs were actually hers. This social pruning is a major contributor to the health crisis. In Spain and Greece, the historical strength of the extended male kinship network, the grandfathers, brothers, and cousins, provides a buffer that the American nuclear family lacks. A divorced father in Madrid is far less likely to spend his Saturday nights alone than a father in Dallas, because the Mediterranean social structure does not allow for that level of individual isolation. The depth of this crisis in the U.S. is further complicated by the stigma of the seeker. Historically, American men have been socialized to tough it out. Seeking mental health support during a divorce is often seen as a sign of weakness that could be used against them in court. A father might fear that attending therapy will lead to his medical records being subpoenaed to prove he is mentally unstable. This creates a dangerous historical trend where men suffer in silence to protect their legal standing, leading to a pressure cooker environment that eventually explodes in a physical or mental health emergency. By comparing these global health outcomes, we see that the U.S. system is uniquely designed to maximize the biological stress on fathers. We prioritize the legal battle over the human biology. We treat the father as a litigation unit, rather than a living organism that requires social and emotional nutrients to survive. But what if the danger isn't just to the father's health? What if the very tools the state uses to protect the family are actually being used to dismantle it? In the next part, we are going to look at the history of false allegations and the silver bullet. We will explore how domestic violence laws, while essential for protection, have historically been used as strategic maneuvers in custody battles. We will compare the U.S. approach to due process with the systems in Sweden and Canada, and we will look at the data on how often these tactics are deployed to gain a temporary advantage that becomes a permanent loss. The intersection of law, safety, and strategy is a minefield, and we are going into the heart of it. Stay tuned for Part 7. The historical intersection of safety legislation and tactical litigation in the United States has created a phenomenon often referred to by legal scholars as the silver bullet. This term describes the strategic use of domestic violence allegations to gain an immediate, unilateral advantage in a custody dispute. To be clear, domestic violence is a grave societal issue, and the laws designed to protect victims are essential. However, the historical trend since the late 1990s shows that the low threshold for obtaining temporary restraining orders (TROs) has inadvertently created a path for fathers to be removed from their homes and children without prior notice or a chance to defend themselves in real time. Imagine a man named Stephen in 2026. Stephen is in the early stages of a contentious separation. One Tuesday evening, while Stephen is at work, his spouse files an ex parte petition for a protection order. In many U.S. jurisdictions, the standard for an ex parte order, meaning an order granted without the other party being present, is exceptionally low, often requiring only an assertion of fear rather than evidence of physical harm. When Stephen returns home, he is met by police officers who serve him with the order. He is given 10 minutes to pack a bag and is barred from contacting his children or returning to his residence for a minimum of 21 days until a full hearing can be held. This initial 3-week gap is the critical historical inflection point. In the U.S. legal system, that period of forced absence allows the other parent to establish a new status quo. By the time the hearing arrives, the father has been out of the home, the children have been told a specific narrative about why he is gone, and the court is often hesitant to disrupt the new arrangement. Historical data from across several states suggests that even if the allegations are later found to be unsubstantiated or dismissed for lack of evidence, the father rarely regains the level of custody he had prior to the filing. The silver bullet doesn't need to be true to be effective. It only needs to be fired. Compare this to the historical evolution of family law in Sweden. Sweden has a robust system for protecting victims of violence, but they have integrated a unique evidentiary safeguard. In Swedish custody cases, the social services agency, known as socialtjänsten, is often involved from day one. They conduct rapid, independent assessments. If an allegation is made, the focus is on a fact-finding mission rather than an immediate punitive removal, unless there is a clear and present danger to life. Historically, Sweden has moved toward a model where the state provides supervised visitation centers as a default temporary measure. This ensures that the father-child bond is never fully severed during the investigation phase. The U.S. approach of total removal followed by a slow-moving legal process is almost non-existent in the Swedish model, which recognizes the psychological damage that a sudden paternal disappearance inflicts on the child. In the United States, the historical shift toward the silver bullet was accelerated by the Violence Against Women Act (VAWA) and its state-level counterparts. While these laws provided necessary funding for shelters and enforcement, they also encouraged a arrest mandatory policy. In a 2026 context, many police departments still operate under these policies where, if a call is made, someone must go to jail. For a father, an arrest record, even if it never leads to a conviction, is a catastrophic blow to his custody chances. It is often used as a historical marker in future hearings to paint him as a high-conflict parent. Now let's look at a case study from Canada. In recent years, Canadian courts have become increasingly vocal about the issue of litigation-driven allegations. In some landmark Canadian cases, judges have gone so far as to sanction parents who are found to have fabricated or grossly exaggerated claims for the purpose of alienating the other parent. This historical pushback is gaining momentum in the Canadian legal system, where the best interests of the child standard is being reinterpreted to include protection from the trauma of false accusations. In the U.S., by contrast, there are very few penalties for filing a false or unsubstantiated TRO petition. The prevailing historical trend is one of better safe than sorry, which, while well-intentioned, often leaves the innocent father with no recourse for the time and reputation he has lost. There is also the historical reality of the default of guilt. Because the family court is a civil court, the standard of proof is not beyond a reasonable doubt, but rather a preponderance of the evidence. This means the judge only needs to believe that the allegation is 51% likely to be true. For an American father in 2026, this creates a precarious environment. If a father is accused of a minor transgression that occurred years ago, it can be revived and used to justify a complete loss of physical custody. In Spain, however, the historical trend has shifted towards specific and recent requirements. Spanish courts are increasingly moving away from using historical, non-violent marital friction as a justification for modern custody decisions, focusing instead on the father's current capacity to parent. The financial cost of defending against a silver bullet is the secondary blow. To clear his name, a father in a city like Boston or Los Angeles may have to hire private investigators, forensic psychologists, and high-level defense attorneys. Historically, this financial exhaustion is a feature, not a bug, of the adversarial system. By the time the father is cleared, he is often bankrupt and too exhausted to continue the fight for shared custody. This leads to what sociologists call the crawlback phase, where the father is granted gradually increasing visitation over the course of several years. He is effectively on probation for his own children, despite having done nothing wrong. Imagine the psychological impact of this probationary fatherhood. In 2026, we are seeing a rise in fathers who simply walk away after being hit with the silver bullet. They feel that the system is so rigged against them that the only way to find peace is to concede. This is a tragedy for the children, who lose a protector based on a legal maneuver. In France, the historical use of the judge of family affairs, juge d'affaires familiales, provides a more holistic view. The judge in France often stays with the same family for years, getting to know the characters and the history. This prevents a new attorney from using a single tactical filing to append a decade of stable parenting. As we analyze these historical trends, it becomes clear that the U.S. has a unique problem with legalized abduction. Under the guise of safety, we have created a mechanism that allows for the rapid and often permanent removal of fathers from their families based on unverified statements. While the safety of the household must be paramount, the global comparison shows that other nations have found ways to protect victims without destroying the fundamental rights of the father and the emotional health of the child. But there is an even deeper historical current at play. Beyond the tactics of the courtroom, there is the global trend of the invisible father in public policy. Why is it that in some countries, a father's role is seen as essential for national stability, while in the US, it's treated as optional? In the next part, we are going to dive into the politics of fatherhood. We will explore how different governments use tax codes, labor laws, and social incentives to either build or break the paternal bond. We will look at why the US has the highest rate of single-parent households in the developed world, and what we can learn from the fatherhood initiatives of nations like Hungary and Singapore. The connection between the state and the cradle is deeper than you think. Stay tuned for Part 8. The politics of fatherhood in the United States is a story of unintended consequences and structural neglect. To understand the landscape of 2026, we have to look at how the American state historically views the male parent. In many ways, the U.S. government has historically treated the father as a secondary social unit, a backup generator that is only called upon when the primary power grid fails. This is most evident in our tax codes and labor policies, which have long incentivized the single-mother household through welfare structures while offering very little in the way of structural support for the divorced father trying to maintain a dual household existence. Imagine a man named Daniel in 2026. Daniel is a middle-class worker who, following his divorce, is trying to maintain a 3-bedroom apartment, so his children have their own space when they stay with him. However, under U.S. tax law, only one parent can typically claim the head of household status and the associated tax credits. Historically, these benefits go to the parent with the most overnights. This means Daniel is taxed at the highest individual rate, despite the fact that his costs of living are artificially inflated by the need to provide a home for his children. The U.S. tax system does not recognize the reality of the secondary parent's expenses. This is a historical trend of fiscal erasure. We tell fathers they must be present, but we tax them as if they are alone. Contrast this with the historical case study of Hungary. Over the last decade, Hungary has implemented some of the most aggressive pro-family policies in the world. While their focus is often on increasing the birth rate, the fallout for divorced fathers is significant. The Hungarian government provides massive tax exemptions and low-interest loans for families. Crucially, these benefits are often structured around the number of children a man has fathered and supports, regardless of whether he lives in the same house as the mother. In Hungary, the state views the father's financial stability as a matter of national security. They recognize that a father who is pushed into poverty by the taxman is a father who cannot invest in the next generation of citizens. Now let's look at the labor market. In the United States, we have a historical lack of paternity leave and flexible work protections for men. In 2026, if Daniel needs to leave work at 3 p.m. to pick up his kids for his scheduled visitation, he often faces a fatherhood penalty. His employer may view him as less committed than his childless or married peers. Historically, the U.S. has relied on the private sector to solve these issues, which has resulted in a massive disparity between high-income tech workers who get unlimited PTO and the blue-collar father who loses his job if he misses a shift for a custody hearing. In Singapore, the historical trend has moved toward the state-mandated protection of the father's role. Singaporean labor laws have evolved to include specific provisions for shared parental leave, and there is a massive social stigma against employers who prevent fathers from fulfilling their parental duties. The Singaporean government views the active father as a key deterrent to juvenile delinquency and social instability. They don't just hope fathers stay involved. They engineer the economy to ensure they can. This includes housing grants that prioritize proximity between divorced parents, so that the father is never more than a few miles away from his children. This historical focus on geographic proximity is something the U.S. completely lacks, often allowing or even encouraging parents to move across state lines, which effectively ends the father-child relationship. The depth of this political issue is also found in the fatherhood initiatives funded by the U.S. government. Historically, since the George W. Bush administration, the U.S. has spent hundreds of millions of dollars on responsible fatherhood grants. However, case studies of these programs show a recurring flaw. They focus almost entirely on teaching low-income fathers how to be better parents, rather than changing the legal and economic structures that keep them away from their kids. We spend money on brochures and seminars while the family court system is still using a 1970s template that defaults to maternal custody. It is a historical example of treating the symptom while ignoring the disease. In the United Kingdom, the politics of fatherhood has been heavily influenced by the Families Need Fathers movement. This group has historically lobbied for a legal presumption of shared parenting. While they haven't achieved a 50-50 mandatory split yet, they have successfully pushed for the Children and Families Act 2014, which requires courts to presume that the involvement of both parents in the life of the child will further the child's welfare. This subtle shift in political language has historical weight. It moves the conversation from "should the father be involved?" to "how do we make the father's involvement work?" The U.S. political landscape remains stalled in a states' rights battle, where a father's rights can change completely simply by crossing the border from Tennessee into North Carolina. Imagine the potential outcomes if the U.S. adopted the French family quotient tax system. In France, the more children you have, the less tax you pay, and this benefit is split between the parents proportional to their involvement. This removes the winner-take-all financial incentive that fuels so many American custody battles. Historically, the U.S. system creates a tax winner and a tax loser in every divorce. This political choice breeds resentment and litigation. We also have to examine the historical data on the single-parent economy. In the United States, there is a multi-billion-dollar industry built around single-parent households, from specialized childcare to legal services to state enforcement agencies. There is a cynical historical argument to be made that the U.S. economy actually benefits from the fragmentation of the family. 2 households mean 2 sets of furniture, 2 utility bills, and 2 legal retainers. Other nations, particularly in the European Union, have looked at the historical cost of family breakdown and decided that the savings of keeping a father in the home, in terms of reduced crime, higher educational attainment, and better mental health, outweigh the short-term economic activity generated by divorce. The 2026 data is clear. Nations that treat fatherhood as a political priority have lower rates of child poverty and higher rates of social mobility. In the U.S., we continue to treat fatherhood as a private lifestyle choice rather than a public good. We have a political culture that celebrates the grind and the hustle, which historically prioritizes the father's output as a worker over his input as a parent. When he fails as a worker because he is trying to be a parent, we punish him. When he fails as a parent because he is trying to be a worker, we label him a deadbeat. This political double-bind is a uniquely American invention. But as we look toward the end of this deep dive, we have to ask, where is the light at the end of the tunnel? Are there states in the U.S. that are finally breaking the mold? And what does the historical data say about the fathers who actually win? In the next part, we are going to look at the shared parenting revolution. We will explore the states like Kentucky and Arizona that have passed 50-50 default custody laws and the shocking results they are seeing. We will look at the case studies of the modern aligned father and the specific strategies they use to thrive in a system that wasn't built for them. We are moving from the problem to the solution. Stay tuned for part 9. The shared parenting revolution is not just a fringe movement. By 2026, it has become the most significant historical shift in American family law since the introduction of no-fault divorce. For decades, the legal community operated under the assumption that a child needed a primary home base to thrive. But as we have seen in previous parts of this masterclass, that model often resulted in the systematic marginalization of fathers. The revolution began when data finally caught up with intuition. Researchers began to observe that the potential outcomes for children in 50-50 shared custody arrangements were consistently superior to those in sole custody households, specifically in areas of emotional health, academic performance, and long-term relationship stability. Imagine a man named Jason in Kentucky. In 2018, Kentucky became the first state in the U.S. to pass a law establishing a rebuttable presumption that joint custody and equal shared parenting time are in the best interests of the child. Before this law, Jason would have entered a courtroom fighting an uphill battle to prove he deserved more than 4 days a month. In the 2026 reality of Kentucky, the burden has shifted. The court starts with the assumption of 50-50. If one parent wants less than that for the other, they must provide clear and convincing evidence of why equal time would be harmful. This historical pivot has fundamentally changed the negotiation table. It has turned a high-conflict litigation process into a logistical discussion about schedules. The case study of Kentucky is a masterclass in societal transformation. In the years following the implementation of House Bill 492, the state saw a significant decrease in the number of contested custody filings. When both parents know the starting point is 50-50, the incentive to pay an attorney $30,000 to win disappears. This has led to what sociologists call the de-escalation effect. By removing the winner-take-all prize, the state effectively removed the fuel for the fire. Following Kentucky's lead, states like Arizona, West Virginia, and Arkansas have passed similar legislation, creating a patchwork of progress across the American landscape. Contrast this with the historical trend in Belgium. While some U.S. states are just now catching up, Belgium passed its law favoring equal shared parenting way back in 2006. The Belgian model is even more rigorous. The law requires judges to prioritize an equal division of time if just one parent requests it. The results over the last 2 decades have been profound. Belgium has one of the lowest rates of parental alienation in Europe. Because the law does not reward the gatekeeper behaviors we discussed in Part 4, those behaviors have largely faded from the legal strategy playbooks of Belgian attorneys. The Belgian experience provides a historical roadmap for the U.S., proving that when the law mandates equality, the culture eventually follows. We must also look at the rise of the modern aligned father. This is a specific demographic of men in 2026 who have learned to navigate the remaining hurdles of the system by using data and documentation. These fathers don't just show up. They utilize parenting apps like Our Family Wizard or Talking Parents to create an immutable digital trail of their involvement. Historically, an American father's word was often weighed against a mother's word in court. By using these tools, the aligned father turns subjective arguments into objective data. He can prove he was at the doctor's appointment, he can prove he sent the school lunch money, and he can prove that his messages regarding the children were respectful and focused. This technological shift is a grassroots solution to the historical bias of the court. Now let's consider an imagine-if scenario regarding the workplace. Imagine if the parental affirmative action seen in countries like Norway was applied to the U.S. In Norway, fathers aren't just allowed to take leave. They are socially and legally expected to. If a Norwegian father doesn't take his daddy quota of leave, the family loses that benefit entirely. This has created a historical trend where men are seen as equally competent caregivers by their employers. In the U.S., the shared parenting revolution is currently clashing with a rigid corporate culture. The aligned father of 2026 is often at the forefront of this battle, demanding flex time not just for personal reasons, but to fulfill his court-mandated 50-50 custody obligations. We are seeing the first historical wave of lawsuits where fathers are suing for discrimination based on their parental status, a move that would have been unthinkable 20 years ago. The financial potential outcomes of this revolution are also starting to manifest. In states with 50-50 presumptions, we see a move toward shared expense models rather than traditional child support models. Instead of one parent writing a check to the other, both parents contribute to a joint account for the child's specific needs: tuition, clothing, extracurriculars. This removes the income transfer stigma that often embitters fathers. It treats the parents like partners in a business where the child is the sole beneficiary. Case studies from Arizona show that this model significantly reduces the deadbeat dad narrative, because the father sees exactly where his money is going. However, the revolution is not without its historical enemies. There is still significant opposition from certain legal associations that profit from the hourly billing generated by high-conflict custody battles. Historically, whenever a 50-50 bill is introduced in a state legislature, it is met with intense lobbying from groups that argue it removes judicial discretion. But as the 2026 data shows, judicial discretion has historically been a synonym for unconscious bias. By standardizing the outcome, the shared parenting revolution is essentially a civil rights movement for fathers, ensuring that a man's relationship with his child isn't dependent on the personal whim or the traditionalist views of a single judge. Look at the historical data from Sweden once again. In Sweden, nearly 50% of all children of divorce live in a 50-50 arrangement. This has led to a phenomenon called parallel parenting. In this model, the parents don't necessarily have to be friends. They simply have to respect each other's time and boundaries. This historical shift away from co-parenting, which requires high levels of communication, to parallel parenting, has been a lifesaver for high-conflict American families. It allows the father to be a full parent in his home without the need for constant, stressful interaction with an ex-spouse who may still be hostile. As we approach the conclusion of this investigation, we see that the American father is at a crossroads. One half of the country is still stuck in a 19th century legal mindset, while the other half is moving toward a future of total parental equality. The success of the shared parenting revolution depends on whether the historical trends of the progressive states can overcome the inertia of the traditionalist states. But there is one final piece to this puzzle. If the law changes and the money changes and the health outcomes improve, what does the actual relationship look like? How do we heal the generational trauma of the absent father myth? In the final part of this masterclass, we are going to look at the legacy of the reconnected father. We will explore the long-term historical impact on children who grow up with a 50-50 father versus those who grew up in the old system. We will look at the global men's shed movement and how fathers are rebuilding their communities. And finally, I will give you a step-by-step synthesis of everything we've learned to help you understand your place in this historical arc. The story isn't over yet. Stay tuned for the finale, part 10. The legacy of the reconnected father is the final frontier in our historical investigation. As we stand in the year 2026, we are witnessing the first generation of children who have reached adulthood under the influence of modern shared parenting movements. This is the culmination of everything we have discussed: the legal battles, the health crises, the financial hurdles, and the political shifts. The data is no longer theoretical. When we look at the historical trends of children raised with high paternal involvement versus those where the father was a mere visitor, the trajectory of their lives is fundamentally altered. Imagine a young woman named Sarah. Her parents divorced in 2010 when she was 5 years old. Unlike many of her peers, her father fought for and maintained a 50-50 schedule during a time when that was still historically rare in her state. Now, as an adult in 2026, Sarah exhibits a specific set of psychological traits that researchers call paternal secure attachment. She has a 33% lower risk of developing clinical anxiety, a higher level of economic self-sufficiency, and perhaps most importantly, she has a blueprint for what a committed, resilient male presence looks like. This is the biological and social compound interest of a father's time. In the United States, the historical narrative has long focused on the damage of divorce, but the new data suggests that the damage isn't the divorce itself. It is the father absence that the legal system historically enforced. Case studies from the early 2020s show that when fathers stay connected, the negative statistics typically associated with broken homes, such as increased dropout rates or early teen pregnancy, virtually disappear. In fact, children in shared parenting homes often score higher on empathy scales because they have had to navigate two different household dynamics, making them more socially adaptable than children in high-conflict nuclear families. Now let's look at a global phenomenon that is helping fathers rebuild their own sense of legacy: the men's shed movement. Originally started in Australia, this historical social shift has spread to Ireland, the UK, and now the United States. These are community-based, non-commercial organizations where men come together to work on woodcraft, electronics, or community projects. For the divorced father who has lost his social circle, the men's shed provides a space to reclaim his identity as a builder and a mentor. Historically, men communicate better shoulder to shoulder than face to face. By rebuilding their social capital in these sheds, fathers are becoming healthier, more stable parents. They are moving away from the isolated victim archetype and into the community elder role. Contrast this with the historical trend in South Korea, where the goose father phenomenon has dominated for decades. In this model, the father stays in Korea to work and fund the family, while the mother and children move abroad for education. These fathers are often socially isolated and emotionally disconnected. However, the South Korean government, recognizing a spike in middle-aged male depression, has begun to implement fatherhood schools. These are state-sponsored programs that teach men how to reintegrate into their children's emotional lives. This highlights a global recognition that the economic-only father is a failed historical experiment. The 2026 global consensus is moving toward the holistic father. To synthesize everything we have learned in this masterclass, we must look at the step-by-step evolution of a father's role through the lens of history. We started in the 19th century with the paternal preference, moved into the 20th century with the tender years doctrine and the deadbeat era, and finally arrived at the 21st century shared parenting revolution. For the American father in 2026, the strategy for success is clear. It is a combination of legal literacy, emotional regulation, and meticulous documentation. The modern father must act as his own historian. Step 1 is recognizing that the system is not personal. It is a legacy of outdated social norms. Step 2 is the rejection of the adversarial trap. Case studies show that fathers who refuse to engage in mudslinging and instead focus on a child-centric documentation strategy have a much higher rate of obtaining favorable potential outcomes. Step 3 is the prioritization of health. A father who is physically and mentally broken cannot fight for his children. The 2026 father recognizes that his fitness, his therapy, and his social circle are actually legal assets. Imagine if we looked at the historical data from Israel once more. In Israel, there is a concept called the heart of the father. It is a cultural understanding that the father's involvement is not a luxury, but a requirement for a stable society. This is the direction the U.S. is slowly heading. We are moving toward a time where the standard possession order is seen as a historical relic, much like the rotary phone or the typewriter. The depth of this change is visible in our schools. In 2026, American teachers are increasingly seeing dual-parent contacts as the norm. The school portals are set up with 2 logins, 2 addresses, and 2 emergency contacts. This administrative shift is a quiet but powerful indicator that the primary parent myth is dying. When the institution expects the father to be there, the father is more likely to show up. This is the expectation effect. In Germany, this is codified in the concept of elterliche Sorge, or parental care, which is legally assumed to be a joint endeavor from the moment of birth, regardless of marital status. However, we must address the grief gap. Historically, men are not given the space to mourn the loss of their family unit. In the US, a man is expected to move on, get a new apartment, and keep working. But the 2026 movement of conscious fathering is changing this. Men are starting to realize that acknowledging the trauma of the silver bullet, or the step-parent trap, is the first step toward healing. By sharing these stories, they are stripping the deadbeat label of its power. They are revealing that many absent fathers were actually pushed fathers. As we conclude part 10 of this deep dive masterclass, we see that the story of the divorced dad is shifting from a tragedy to an epic. It is a story of men who refuse to be erased. It is a story of a legal system that is finally, painfully, being dragged into the 21st century. The historical comparison proves that the US is not an island. We are part of a global movement toward parental equality. Whether it is the mandatory mediation of Scandinavia, the anti-alienation laws of Brazil, or the 50-50 presumptions of Kentucky, the trend line is clear. For those of you watching this today, your role in this history is still being written. Every time you show up for a midweek dinner, every time you document a communication, and every time you prioritize your health over the conflict, you are contributing to a new historical data point. You are showing the court, the state, and your children that the American father is an irreplaceable pillar. This concludes our 10-part masterclass on the historical comparison of divorced dads. We have covered the law, the money, the health, and the future. But the conversation doesn't end here. We are about to launch a new series specifically on the economics of the dual household, where we will dive into the specific tax strategies and housing models that are helping fathers thrive in 2026. We will look at nesting arrangements and the micro-community movement. If you thought this deep dive was intense, wait until you see the financial blueprints we have prepared. The path to a new legacy is just beginning. Keep your eyes on the data and your heart on your children. See you in the next series.